Morning, please be seated. We're here for oral argument on Knight et al. Versus Fontes et al. It's our number CB24-0220. Everyone is experienced counsel. You know you have 20 minutes. Keep whatever time you wish, and there's a clock at the podium for you to do that. With that, Mr. Gould.
Thank you, Your Honor. Andrew Gould for petitioners, Knight, Ramsey, and White. I will aspirationally try to reserve 2 minutes for rebuttal. The issue before this court really turns on how you define the electorate for retention elections for the Court of Appeals. The Constitution, when it wants to, can define the electorate as a county-based or a district-based electorate. It does not define the electorate for the Court of Appeals as either a county-based electorate or a district-based electorate. Specifically, when it talks about Superior Court judges, it talks about qualified electors of the county with both elections and with retention elections. When it talks about districts for legislators, it specifically mentions districts. But when you get to Article 6, Section 9, in the intermediate courts, the Court of Appeals, it doesn't use the word county electors or electors of county. It doesn't use district. It's silent. The only place where there's any reference that gives us indication in viewing this Constitution as a whole as to what the electorate is for a Court of Appeals retention election is Article 6, Section 38. And there, Court of Appeals judges are grouped with this court, the Supreme Court. Specifically, where you file your retention paperwork as a Court of Appeals judge is with the Secretary of State, just as the Supreme Court does. That's the statewide election officer. And in that same section, where you file your paperwork as a Superior Court judge is with the clerk of the Board of Supervisors in the county in which you sit. So the Constitution makes it very clear that the proper electorate for a Court of Appeals retention election is statewide.
Counsel, let me ask you a question about that, because I think it's not an unreasonable inference, but when you define electorate, some of the things that I'm looking at is first, there may not be a particular reference to the Court of Appeals because the legislature is given the authority to create an intermediate Court of Appeals. The legislature is given the authority to decide its jurisdiction. So that's one component of what I'm looking at here. Then the other provision is what you just referenced, Article 6, Section 38, that the people adopted through initiative. And then we also have in the middle of all that the statute in question. And so, as you know, we try to read all these provisions together and treat it as one comprehensive plan. So my basic question to you with all that as context then is, why can't we read all of this in context then and try to harmonize it as we must to find that there has to be this type of geographic distribution for an electorate in order for this to make sense?
Because the legislature can't define the electorate for the Court of Appeals that violates the Constitution. So if the Constitution states that the proper electorate for the Court of Appeals is statewide.
But that's an inference, right?
Well,
I got your argument earlier, but I see that as an inference, and I don't see that as something that's explicitly written that then becomes a fulcrum point for our interpretation.
I disagree, Your Honor. And let me explain. When you look at Article 6, Section 12, Superior Court Terms of Office, it specifically says judges of the Superior Court shall be elected by the qualified electors of the counties. When you look at Article 6, Section 37, retention elections, subsection B, it says judges of the Superior Court shall be subject to retention or rejection by the vote of the qualified electors of the county from which they are appointed. When you look at Article 4, Part 2, Section 1, with respect to legislators, it says the members will be elected from each of the 30 legislative districts. So the Constitution is very clear that when it wants to set aside a district or a county-based electorate, it will do so. Article 6, Section 9 has no reference to counties or districts. And so we have to read the Constitution as a whole. And when you get to Article 6, Section 38A, it specifically says a justice or judge of the Supreme Court or intermediate appellate court, which is the Court of Appeals, shall file in the office of the Secretary of State. And in that same section, it says that Superior Court judges in counties file with the clerk of the Board of Supervisors for the county. So reading those provisions as a whole, there is no language that limits this court or the Court of Appeals to a countywide election. And keep in mind, there's nothing expressed in the Constitution that says this court stands for elections statewide. You won't find that phrase, but by inference, it's not a county-based electorate, it's not a district-based electorate, and when you look at retention elections, both this court and the Court of Appeals file with the state officer, the Secretary of State, whereas the Superior Court judges file in the county where they sit. So I think the Constitution is very clear. So if that's the case, then what we have is the legislature has enacted a statute that divides up the electorate for a statewide office into districts, and worse yet, those districts are unequal. Depending on where you live in the state, your vote may count less or more. In fact, you are discriminated against based on where you live. And so not only does the legislature not have the authority to carve up these districts, but the districts they've created violate the Free and Equal Elections Clause and the Equal Privilege and Immunity Clause.
So looking at that, I'm just wondering that looking at your briefs, it seems like I didn't remember hearing that argument. I mean, what you just said seemed to be arguing that the Constitution itself, by necessary implication, requires that Court of Appeals judges be on have a statewide electorate and therefore be on a statewide ballot. Whereas the issues that we took and where you argued were more the fact that the legislature enacted the methodology for retaining Court of Appeals judges violates provisions of the Constitution, the Free and Equal Elections and the Privileges and Immunities Clause. Am I getting that incorrect? Is this new, or did I miss it?
It's not new. If you look at our reply brief, page 14, note 9, we talk about it, page 3, page 15, page 25, our opening brief, page 1, page 20. It's all throughout our briefing. We repeatedly state there's a difference between the constitutional provisions that set up the electorate for superior courts versus the Court of Appeals. We talk about all of these sections, Article 6, Section 38A, how the Court of Appeals judges are grouped with the Supreme Court justices.
You do, but I thought it was more in the context that you were setting, the historical context, the importance that Arizona has placed upon originally electing judges and then later going to retention, why this is all part of why it's going to ultimately fall into the free and free and equal elections. Thank you, Free and Equal Elections Clause.
Well, Your Honor, those discussions are to help give context and help the court interpret it. So in terms of the accountability, the history of these clauses, it supports the argument in terms of all judges, whatever their electorate is, need to be accountable. And so where that plays in is this. As Division I has grown, as Division II has grown, as they've moved away in 1974 from direct elections to retention elections, the accountability has stretched thin. And now, with the unequal geographic divisions, with the discriminatory divisions that are placed on these Court of Appeals judges, that accountability is removed. The very thing that was underlying the adoption of our Constitution is that judges have to be accountable to their electorate.
Okay,
But the Constitution by itself...
Just to be clear, so I know that we're addressing your arguments, then you're arguing that primarily, it sounds like, that ARS 120.02 is unconstitutional because it violates the scheme that the legislature, that the constitutional framers set up for how Court of Appeals judges must be retained.
Yes.
Okay, and then if you get by that, or if we get by that saying no, it doesn't violate it, it violates other provisions of the Free and Equal Elections Clause and the Privilege and Immunities Clause.
Right.
Okay.
So if the Constitution were to define the electorate for the Court of Appeals as a county-based electorate or a district-based electorate, then ARS 12-120.02 would be constitutional, because within the county bases or the groupings of counties or these geographic districts, the votes are equal. But if it's a statewide electorate, they're not, because depending on where you live, your vote counts for less, or you may not be able to vote at all.
So if I understood that last point you made, then if we were to disagree that the electorate is defined as you're arguing, then there's no issue.
Well, that's right, Your Honor. It's what the Constitution says or it doesn't. And that's why this case is unique from any other case out of state. It's why it has nothing to do with apportionment cases. Apportionment is one person, one vote, but those cases don't even discuss what is the electorate, what is the group of people that the Arizona Constitution defines as the people who have the right to vote in a Court of Appeals retention election.
So with the provisions you were discussing, though, with respect to where someone files for a retention election, why does that matter if, for administrative ease, without constitutional import, someone who is appointed from several rural counties, either in Division I or Division II, instead of having to go file in each one of those counties, they just file with the Secretary of State?
Why does it matter if they file with the Secretary of State versus filing with each of the counties?
In terms of it having constitutional import, why does it make a difference that the legislature saw fit to have them file with the Secretary of State versus, or the people through initiative file with the Secretary of State versus each of the different rural counties?
Because it's the only place that talks about where you, as a Supreme Court, have to file. And the Court of Appeals is grouped with you on where you file. And the Superior Court is directed to file in a different location. And so that tells us that by its terms, impliedly and even expressly, the Court of Appeals judges, in terms of their electorate, is the same as this court. Again, there's no constitutional provision that says the Arizona Supreme Court stands for statewide election. The only place it really addresses it is your retention election where you file. And so that's the significance of it, Your Honor.
So don't we assume, though, that when the people passed that initiative, they knew about 120.02? They knew that Court of Appeals judges were being retained in the manner in which you had some rural judges being voted on in rural counties and otherwise? Isn't that one of our canons of interpretation, that the people knew what the law was when they voted for that? Isn't that somehow then, when we read it all together, don't we have to harmonize with it rather than single it out?
Well, what you're doing, Your Honor, is you're placing a statute above the Constitution, and that's something that you can't do.
Well, what I'm trying to do is read it all together. And so
Well,
I guess maybe to reiterate the point or state it a different way, if the people passed their initiative that called for the appointment of Court of Appeals judges in the same way that they were being voted on for retention, where's the problem?
Well, Article 6, Section 38A is new. That was
Right.
added. It didn't exist. So you have a completely new constitutional provision that directs where judges file for retention election. Your Honor, when 12-12002 is adopted, everybody was directly elected. Superior Court, Court of Appeals, Supreme Court, everyone was directly elected. And to obtain any type of diversity, and when the court talks about, it's in Article 6, Section 9, composition of the court, the only way you can obtain geographical diversity in direct elections is you have to have judges stand for election in certain geographical areas. But once you do away with retention elections and you can appoint from different geographical areas in the state, you no longer have to elect, you no longer have to have retention elections, because a person can be appointed from a rural county, and whether they win or lose their retention election, the next person that's appointed is going to be from a rural county as well. So that comprising of the Court of Appeals with direct elections perhaps made sense in terms of setting up districts. The other thing that changed was these two divisions early on operated almost like separate circuits. In fact, I can remember a time as a young lawyer where if you were in Division I and there was a contrary decision in Division II, the law said you had to follow the Division I authority. That has been wiped away for 30 years now. The case law is very clear. Whichever division issues the decision, whichever is more persuasive. But it wasn't always that way. The other thing that happened early on was you not only had direct elections, you had very small courts, and not a lot of cases moving back and forth. Now you have 19 judges on Division I. You have 9 judges on Division II. You have a statute that calls for equalization. You have constant movement of cases back and forth, and the courts have done away with the old rule you have to follow Division I or Division II. So there was a time when that statute was first passed where it might have made sense, and those direct elections might have made sense because they operated as separate circuits or essentially as so, but they don't now. That's been wiped away a long time
Even before
ago.
then, though, even before the latest statute expanding the court, they did go back and forth. Cases went back, all the workers' comp cases, for example, where the lawyers lived in Division II, went to Division II, even though by statute, they should all have gone to Division I. That's just an example. Anytime conflicts. There was always a back and forth, even before the legislative explicit authority to do so. So, I mean, hasn't this issue always kind of been around that you're talking about, the consequence?
It's been growing, Your Honor. It's changed over time. It was not originally so when they had 3 judges in each of these divisions. But it has changed, and more we see it. And that's the point, is that in 1974, the direct elections are done away with. And at that point, these geographic limitations on where a judge stands for election no longer make sense. Then you have increasing movement between the courts. Then you do away with this old rule that Division I and Division II govern the citizens in their respective divisions. And so it has been, and it's been going on for a long time. And now, and for maybe 20 years, the cases move freely.
Mm-hmm. But you raise, I think, very good policy points. But that's what they strike me as, policy points. How does 120.02 violate the Arizona Constitution? Why is, what's the violation? Maybe you can move into that.
Because it requires judges to run based on geographic divisions in the state. And under the Constitution, when you read all the provisions together, judges on Division I and Division II have statewide electorates. And so what the legislature has done is it's violated the Constitution. It's divided up a statewide electorate into geographical districts. There's absolutely nothing in the Constitution that supports or justifies county-based electorates for Division I or Division II judges. There's not a word in the Constitution that supports it. There's not a word in the Constitution that supports dividing up Court of Appeals judges into districts. Nowhere. And the fact that the Constitution knows when to include those terms and does so for Superior Court and for legislative districts is important. And then the only provision that addresses how this court stands for election, it groups together Court of Appeals judges with the Supreme Court. And we know the Supreme Court has statewide jurisdiction. And so does the Court of Appeals. A decision in the Court of Appeals is binding on the state.
Well, so does that also mean then that the appointment of Court of Appeals judges from 10 from Maricopa, 4 at large, 5 out county, that kind of thing, that also similarly runs afoul of the Constitution, because effectively they have divided it up into districts?
No, Your Honor, because that's an appointment. That's not an election. What we're arguing today is that retention elections violate the Constitution, not appointment of
Counsel,
judges.
can I ask a question? With respect to jurisdiction then and the distinction about
I knew that Justice Montgomery would run out my 2 minutes. Yes, Justice.
I'm going to try to sneak one in clock second.
And I'm sure if you're kind and you ask the Chief Justice for her favor, you may get an extension.
Oh, please don't make me do that.
So the tax court is unconstitutional because the tax court issues decisions that bind people throughout the state, but only the residents of Maricopa County get to vote for that judge's retention. Mm-hmm. And I know you broached this argument before the trial court, but I wasn't able to find a clear principle that I could discern from that made that distinct from the argument here.
Well, of course, Your Honor, that's a Superior Court.
But if your point is this, and this is the broader principle that I'm trying to get, if you have a right to vote for a judge who issues rulings that bind you,
that's not the principle, Your Honor. That's not the principle.
Okay,
the principle is what is the electorate that you are elected by? With all due respect, Your Honor, you have it backwards. It's not who binds you. It's the people's right to vote for a judge. So what is the group of people that have the right under the Constitution to vote for you, to vote for Court of Appeals judges, to vote for Superior Court judges?
So it's unconstitutional then to not let the people of Yuma vote for the tax court judge?
It has nothing to do with that. This is the jurisdiction of the Court of Appeals. And what does the Constitution say about the Court of Appeals? There's plenty of case law that says Superior Court judges, to have general subject matter jurisdiction over the state, but the fact of the matter is that a judge who sits in essentially a superior court role as tax court is still a superior court judge, still has general subject matter jurisdiction throughout the state. Think of it this way, Your Honor. Maricopa judges that currently under 12-120-02 stand for election in Maricopa County, what does the Constitution direct them to do as to where they file their retention paperwork? They only sit in Maricopa County, but they don't file with the Maricopa County Clerk of the Board of Supervisors. The Constitution expressly directs them not to. It directs them expressly to file it with the Secretary of State. The same thing with a judge in Pima County. They're in Pima County. Why don't they file with the Board of Supervisors in Pima County? Why does the Constitution direct them to file with the Secretary of State with the Supreme Court? Because they're a statewide electorate, Your Honor. Thank you.
Oh, yeah, Mr. Gould, if you could hold on, we have one more question for you.
See, she is nice about giving
I don't know if this is nice or not, but
It may not be nice to you, but it's nice to me.
fair enough.
Quick question. With regard to, you talked about Article 6, Section 38, but not Article 6, Section 37D, which strikes me as contemplating appellate judges coming from specific counties, and to Justice Montgomery's earlier point, seem to contemplate the existing system. Any different analysis on that?
Yes, because the difference between appointment, which is guided by ARS 12-120, is not the same as an election under 12-120-02. So when you come to bear with the equal election clause or equal privileges and immunities as to election, it doesn't matter where they're appointed from. It matters where they hold office and where they're elected. Again, the frame of reference has to be what is the electorate for the Court of Appeals. Once you determine what that electorate is, that generates and mandates who can vote and whether or not you can divide it up into districts or not.
Okay, thank you. Okay, and I tell you what, if you could you add for me 2 minutes for each side, because we took a lot of questions on that. So I'll give you your 2 minutes, but add two to the state side as well. So please proceed.
Good morning. May it please the court, Emma Mark for the state of Arizona. Arizona's judicial election system has always been intended to be a system divided along geographic lines, both for the Superior Court and for the Court of Appeals, even though those courts are singular courts with statewide jurisdiction. And that's because the system is not based on the fictional principle that the scope of judicial authority or the reach of a court's jurisdiction defines its electorate. It was intended to give every voter a say while still balancing the diverse interests of Arizona's urban and rural populations. Plaintiffs have provided no support for the proposition that they have a constitutionally protected interest in voting for every judge who exercises statewide jurisdiction.
Well, how do you respond to Mr. Gould's point that he emphasized in his statements that in the constitutional framework, at least, the Court of Appeals authorizations lumped in with the Supreme Court, the electorate seems to at least implicitly apply a statewide reach, a statewide electorate. So I take it from his argument that he's saying that that's the authority for the fact that the electorate is everyone in the state.
Yes, a couple of things I'd like to say in response to that, and as you pointed out, Justice Timmer, this seems to be yet another sort of new theory of plaintiffs. Plaintiffs are absolutely right that the Constitution does not define the scope of the electorate for the Court of Appeals, and that's because the court is created by the legislature. It is a legislative body, and that discretion is committed to the legislature to determine the makeup of the court. I would point the court's attention, as Justice Bollock mentioned, to Section 37D, which provides that a person appointed to fill a vacancy on the Court of Appeals shall be a resident of the county or counties where the vacancy exists. It contemplates that a vacancy is going to be created in a geographically defined area, and that the new judge appointed to fill that position is going to come from that same geographically defined area, that the voters within a specific area will continue to have a voice in the process. And as Justice Montgomery mentioned, when Section 37 was added to the Constitution, 120.02 was already in existence. And I think he's exactly right that the voters knew that the system we have in place for the Court of Appeals existed. It has always been this system divided along geographic lines. And so it makes sense that those same lines would continue to exist. And with respect to counsel's argument about, this court, Section 38 doesn't require statewide elections for this court. But there's parity, right, between the merit selection process for this court and the electorate. Justices on this court can come from anywhere in the state. There's no restrictions, there's no provisions for where Supreme Court justices should come from. And so it makes sense that the electorate is then statewide. For the Court of Appeals, there are constitutional restrictions on where those judges can be appointed from one of these 4 geographic areas. And so it makes sense that there is parity in the system in terms of the retention of those same judges.
Well, but could the legislature then, since there's nothing in the Constitution about where Supreme Court justices have to stand for retention, could the legislature pass a bill simply saying it should only be the voters in Maricopa County? Only Maricopa County will vote in retention elections for Supreme Court justices. Would that violate the Constitution?
So I don't think that would violate these specific provisions of the Constitution, Section 37 and Section 38. I think there are other constitutional problems with that system. I think that system might violate equal privileges and immunities. There seem to be some sort of equal protection principles at stake there. But I think if the legislature wanted to provide a different system for the retention elections of this court or the Court of Appeals, it could do that so long as it was constitutional in other ways.
How would it violate the equal privileges and immunities provision?
If only one county got to vote. Well, that seems sort of arbitrary and kind of fundamentally
doesn't seem fair, but
unfair, yes, to give only the voters in one county a say over what the court looks like. And this is actually something that Wells talked about as well. So Wells held, the concept of proportional voting districts at the core of one person, one vote. That doesn't apply to judicial elections because judges are different. We recognize that judges play a different role in our government. However, the court did recognize that there were limitations to that. So if a state had not only distinguished between citizens, but that distinction was arbitrary and capricious, then someone could probably state an equal protection claim. And so that seems like it might sort of fall within that category. This case is nowhere close to that line. Every voter is given a say here, and every voter within each geographic area is treated equally.
Now, I recognize that the Court of Appeals is different because we've got a provision that empowers the legislature to construct it in certain ways, and these other provisions that we've talked about. But the one thing I want to make sure we don't do is to dilute the importance of the free and equal elections clause. Now, if there was a county board of supervisors that had districts and one was twice the size of another, would that implicate the clause?
Maybe. So the free and equal elections clause has really only been applied in 2 cases, one Court of Appeals case and one case before this court. It's not clear that it encompasses claims like that, claims of vote dilution. So far, it's really only been applied when we're talking about sort of the mechanics of an election. Are people being completely disenfranchised? That kind of thing. However, this is where I think the Eugster case is really instructive. So there, the Washington Supreme Court recognized that we already have a framework when we're analyzing these kinds of vote dilution claims, and that framework falls under the Equal Protection Clause. And so under the logic of that framework, like Wells, voting districts don't need to be numerically equal in order to, pass constitutional muster for judicial elections. And so I think the court could say something similar here if it were going to answer that question.
Well, I think of that case as the poster child case for diluting the meaning of the provision, because among other things, it held that essentially only a complete suppression of voting opportunities was contemplated, and to me that's very different than free and especially equal. In Chavez, the court, which we have subsequently cited, the Court of Appeals said that the equal provision of this clause guarantees that, and here I'm quoting, each vote is given the same weight as every other ballot. And I think that's the gravamen of the plaintiff's concern here, is that in some districts, with regard to the Court of Appeals, it takes 250,000 votes to retain a judge. In another one, it's less than maybe 50,000. Why would that not violate that principle?
So I have a couple of responses I'd like to give on that point. The first is that plaintiffs are not actually making a vote dilution claim. And it's kind of confusing because their arguments on this have shifted throughout this case, but they have talked a lot about the proportionality of voting districts and the number of judges on the court, and whether that results in, people's votes being weighted more heavily than other people's votes. That is a vote dilution, one person, one vote claim. And plaintiffs have expressly disavowed that they're making that claim. They say, this isn't a one person, one vote case. This isn't about apportionment. We don't want equipopulous voting districts. And they can't, right? They can't make that claim because it directly contradicts with the premise of their case, which is that you cannot have districts at all when it comes to the Court of Appeals, because the Court of Appeals jurisdiction defines its electorate. Those elections have to be statewide. So keeping that in mind, I don't even think this is a question the court needs to answer in this case, because it's not a claim that plaintiffs are making. Assuming they are making a vote dilution claim, I think it makes sense for the court to apply federal equal protection standards to claims under the Free and Equal Elections Clause and under the Equal Privileges and Immunities Clause when we're talking about election vote dilution cases. And Arizona courts have done that in the past, right? This was true in Chavez v. Brewer and in Minority Coalition for Redistricting, the 2005 Arizona Court of Appeals case. The court applied federal equal protection principles, even though those claims were made under both the the Equal Privileges and Immunities Clause and the federal Constitution.
Counsel, let me ask you a question about that, though. Can we apply those principles without tying ourselves to federal equal protection jurisprudence? It's our Constitution, and it seems to me it's a little bit problematic for us to take two different provisions in our Constitution and hitch it to one body of jurisprudence at the federal level. So maybe if you could take just a moment and underscore which principles you think we should be applying.
So I think the court should apply the principles in Wells if we're talking about vote dilution claims, which are that given the role that judges play in our form of government, the representational interests, the reason we care about proportional voting districts just aren't applicable. And I think that applies both in the free and equal elections context and in the equal privileges and immunities context. In other contexts, the court can apply a single test when state action implicates different constitutional rights. So for instance, a ballot access restriction, although it might burden a plaintiff's First and 14th Amendment rights, there's one framework for analyzing the constitutionality of all ballot access restrictions, and that's from Arizonans for Second Chances v. Hobbs. And so I don't think it is sort of out of the question for the court to say, when we're talking about the narrow issue of vote dilution, we're going to analyze those specific claims, whether they're brought under the Free and Equal Elections Clause or whether they're brought under the Equal Privileges and Immunities Clause, the same way.
Okay. one related question to that then, there is, an allure to the basic logic that if a judge is going to issue a ruling that affects me, I ought to have some oversight to some degree as a voter. Is there a limit to what the legislature can do in determining the jurisdiction of the Court of Appeals, where we would say, now you've gone too far. Now you've arranged this in such a way that you have caused constitutional concerns?
Sure, and I would point the court back to the reasoning in Wells that the legislature can't act in a way that's arbitrary or capricious. And if it's doing that, and if it's acting in a way that, it doesn't even survive rational basis, I think that's an easy line to draw. But here, where we're talking about a system where the Constitution contemplates that judges are going to be elected from certain appointed from certain geographic areas, when the legislature says, yeah, and we're also going to have retention elections for judges from those same geographic areas, so that there's parity in the system, and so that every voter gets a say, that doesn't even come close to that line. And I think, and plaintiffs, given their sort of proposed remedy, if we have a statewide retention election but maintain this geographically based merit selection process, I don't think it's difficult to envision a scenario where Maricopa County voters consistently overwhelm and outnumber the voters from rural counties. So Maricopa County voters could consistently decide not to re-elect judges from rural areas and wait until, new people keep getting appointed from those rural areas until Maricopa County voters get someone that they want. And that doesn't really seem fair either. So this system is a way to give everybody a say in the judges that come from their geographic area.
In terms of mooring the authority to the legislature, does Article 6, Section 9, is your argument that is the constitutional provision that confers the authority on the legislature to establish these geographic areas for retention elections? And is that, if so, is that your response to your opponent's claim that Article 6, Section 38A at least infers or implies that the statewide electorate is the only constitutional electorate for retention of Court of Appeals judges?
Yes, absolutely. And I think not only is the discretion of sort of the composition and the jurisdiction, of what the Court of Appeals looks like committed to the legislature sort of by Constitution, the Court of Appeals is different from the Supreme Court and the Superior Court because those courts are contemplated in the Constitution, right? Like those are creatures of the Constitution. They've been here from the beginning, and the Court of Appeals isn't. It's different. I would also say, with respect to counsel's specific argument about, Court of Appeals judges being required to let the Secretary of State know that they're running for retention, and that we can infer from that it's supposed to be a statewide electorate. I think the easy answer to that is the out-county judges. So if you're a judge in Division I and you're not in Maricopa, what county board of supervisors do you file your notice with? Because you're subject to the retention election of multiple counties. So I think filing with the Secretary of State is a matter of convenience and takes into account the geographic system. It is not a directive for statewide retention elections.
I had a question that I ran out of time with Mr. Gould, but I think either of you can answer it. There's you are both quarreling over mandamus here. If we were to find that this was a constitutional violation, isn't the proper action for us to simply declare the law unconstitutional and then let the political branches deal with this in the first instance? Yes, absolutely. And plaintiffs actually acknowledge in their reply brief at page 20 that other alternatives
might exist, even within their jurisdictional framing, that, well, equally populated districts might pass constitutional muster. I think that really highlights how inappropriate mandamus is in this case, is that even plaintiffs concede there are other ways that the legislature could do this that they don't think would be constitutional. So if that's the case, then clearly the Secretary of State does not have a non-discretionary legal duty to enact the specific election scheme that plaintiffs would like. The trial court found that an equal retention election for the Court of Appeals judges is not defined by the court's statewide jurisdiction, and similarly that equal does not mean that all Arizona voters will be able to vote on all Court of Appeals judges. The trial court was correct. Without that foundation, plaintiffs have no basis for their claim. Thank you.
Thank you. Okay, Mr. Gould.
First off, Justice Bullock, of course this court could direct the Secretary of State to follow the Constitution and direct that these Court of Appeals judges be placed in the ballot. There's absolutely nothing that prevents that. In terms of what we stated in our brief, is there a conceivable way that the legislature could divide up the state into districts that would comply with the Constitution and also not violate the Free and Equal Elections Clause? Conceivably, it's hard to imagine. It'd have to be something like 4 equal circuits or 2 equal circuits. But that's just a speculative idea. Your Honor, the bottom line is this.
But counsel, if there is the possibility, speculative as it may be, that there are other options, why should we select the option to be imposed?
Because mandamus directs a public official, a state official, to do what they're bound to do by law. And under Article 6, Section 38, Court of Appeals judges stand statewide for elections. So the Secretary of State, not only is the officer responsible for taking those declarations, but responsible for placing them on the ballot. And we've done this before in other cases, or you have done this before in other cases.
Right, but you just conceded that there is the possibility of a different system. So my question is, why should we select the system you propose?
Well, right now it's the only system that is constitutional. I mean, the idea that there might be something that the legislature could come up with, as it stands now, this system is unconstitutional, and you would be clearly within your authority and your constitutional authority to direct the Secretary of State to put them on a statewide ballot.
Or simply to declare it unconstitutional?
You can. I mean, if that's, the option that you choose. But my argument would be you have the authority under mandamus to direct the Secretary of State to put these judges on the statewide ballot. I hear a lot about parity in the briefs. I find the word parity nowhere in the Constitution regarding retention elections for any court. It is equality that is the issue. And the issue and the principle here is simply this. Similarly situated voters have to be treated equally in this state. And if the electorate for the Court of Appeals is statewide, then you cannot discriminate against voters based on where they live. It is a basic constitutional principle. This system set up by 12/1/2002 discriminates based upon where you live. And so it is not free and equal, and it violates equal privileges and immunity clause. In addition, this idea about appointments, that the legislature can come up with anything that it wants in terms of where it's appointed. The challenge is the election. Is the election, the retention election, free and equal?
Mr.
Yes.
Gould, you are at your end.
Oh, thank you.
Thank you, and thank both counsel. Excellent argument on both sides. Excellent briefing. We will take the matter under advisement and issue a decision in due course. Till then, we stand adjourned.